This is very important that you have this seal that no one will ever be able to find out anything about your trust if it were to ever come out in a court proceeding. A big part of my practice is dedicated to domestic asset protection trusts. And if you watch any of my videos, then you know I love South Dakota because it's the best trust jurisdiction in the country and very competitive among jurisdictions even throughout the world. But when it comes to asset protection trusts, it's the best. I recently had a conversation with a prospective client. We had talked about South Dakota trust planning. They'd done their own due diligence, done some research, talked to other attorneys, talked to some local trust companies. We're located in Texas, even though I help clients throughout the country with these domestic asset protection trusts. And the feedback that he received was, you gotta focus on Nevada. Okay, so keep that in mind. I asked him why, and he said that he was told that Nevada has the best domestic asset protection trust statutes on the books. And I said, they're great. And Nevada and South Dakota are known for being the premier trust jurisdictions in the country. And he said, well, I want to do Nevada. I don't want to do South Dakota. And I said, what was said to change your mind about this? And he was told that Nevada doesn't allow for exception creditors, whereas South Dakota does allow exception creditors. And what this means is that the state allows there to be creditors who can have a personal claim towards any assets that you moved into your domestic asset trust. But they're defined by law. These exception creditors are defined, they're spelled out on the books so we know who they are. So the prospective client was right. Nevada doesn't have any exception creditors whatsoever, so no one can pierce that trust when the planning is done correctly. Whereas in South Dakota and other states, that isn't always the case. So the exception creditor in South Dakota is for alimony owed to a ex-spouse or child support. But here's the hook. The alimony and the child support has to have existed. The claims for both of those have to have existed. You've had to owe that money to an ex-spouse or for your children before you ever set up the DAPT, the Domestic Asset Protection Trust, and ever funded it. I personally, I don't want to help someone that already owes alimony or child support, so I have moral issues with that and ethical issues with that. And so if somebody's coming to me with that particular issue, then I can't help them. But even though South Dakota offers these exception creditors opportunity, South Dakota is still better. So there's an attorney in Las Vegas, Nevada named Steve Oshins, O-S-H-I-N-S. And if you go to his website for his law firm, oshins.com, he has what he does these rankings of the best trust jurisdictions within the United States. And he focuses on 4 different things, and I just want to focus on 2 that are related to this conversation. The first one is domestic asset protection trust. So if you look at those charts, you'll see that number 1, he lists Nevada. He's in Nevada. Number 2 is South Dakota. The only difference between those 2 rankings, how he weights them, is that exception creditor in South Dakota for existing alimony and child support. But again, if that's not your situation, then you don't have any exception creditors that could come through. But here's what's not accounted for in that ranking for domestic asset protection trusts, and it is decanting. So decanting means you have the ability to take assets from an existing irrevocable trust and move them over to another trust, whether it's a brand new trust or a trust that already existed. And so South Dakota has by far the most flexible decanting laws on its books compared to any other jurisdiction, including Nevada. And why is this important? It's important because it gives us backdoor strategies to exit a domestic asset protection trust if we figure out it's no longer working for the client. You have more flexibility. You're not getting locked into something that doesn't work for you long term. So that's something to remember. And like I said, he has rankings there, and he talks about the states with the best decanting statutes. And so South Dakota is number one there. Something else that doesn't get talked about in this conversation about the best jurisdictions when it comes to domestic asset protection trust is privacy. Privacy and quiet trust laws, but really privacy. So it's not secrecy, it's just that South Dakota has this rule that if any details of a trust come out within a court hearing in South Dakota, so if someone had a claim against you, they would have to bring it against your trustee in South Dakota, so it would be brought before a South Dakota court. The rule states that any details regarding the trust have a perpetual seal and can never be subject to public domain, to the public eye. So it has the greatest level of privacy that a trust could ever have, an irrevocable trust, that is. Nevada doesn't have anything on its books regarding that. Delaware has something similar, but not nearly as strong. It offers a judge discretion to put a seal on any details related to a trust that come out during a Delaware court proceeding. However, they only have 3 years that seal can last, unlike South Dakota, which has a perpetual seal, meaning it can last forever. So if creditor protection really is important to you, and you might be subject to lawsuits and creditors trying to enforce claims, this is very important that you have this seal, that no one will ever be able to find out anything about your trust if it were to ever come out in a court proceeding. The other thing is that you can eliminate the ability of any beneficiary. Now, typically with a domestic asset protection trust, you are the beneficiary. You, the client who are setting up the trust, are the beneficiary. But sometimes you might set someone else up as a beneficiary of that trust. You can eliminate the ability of that beneficiary to have access to any of that information. And other states just don't do that. So between the decanting and between the privacy laws, this is what really pushes South Dakota above Nevada for every reason.